Okay, we're up to stage 5 in the 10 stages of a federal criminal trial. And this week we're talking about what does the defendant do when it's his turn up to the plate. So stick around and let's talk about that. Happy Friday, everybody. Hope you're having a great week and gearing up for another awesome weekend. It has been storming here in Dallas, so we have been inundated with flash flood warnings and severe thunderstorm warnings, but that's okay. We're still kicking. And now, this week, we are talking about the 5th stage in what has been this ongoing series of the 10 stages of a federal criminal trial. Last week, we talked about stage 4, which is the government's case in chief, right? And I told you about that's where the bulk of the trial happens. It's when the government has to put on all of their witnesses and prove their case. Well, now it's the defendant's turn. Once the government has put forward all of the evidence that they feel proves their case, they rest. They will stand up and they will let the judge and the jury and defense counsel know that they are done submitting evidence to the court. And so they will say, ladies and gentlemen, the government rests. That means that they are done with their case in chief. So now it's the defendant's turn. And as you might expect, the defendant's case in chief is very, very similar to the prosecutor's case in chief. It's where the defense counsel gets to put on any witnesses or admit any exhibits that he or she feels prove their case, right? Now, I say prove their case, but remember, the defendant does not have any burden of proof, typically, right? It is not his job or her job to prove his innocence or her innocence. That's not the job. What the defense counsel is attempting to do is elicit testimony, get witnesses on the stand, and admit exhibits that poke holes in the government's case, right? That will go to disprove something that the government said during their case in chief. That's typically the strategy. Now, you hear me keep using the word typically, and that's because there are certain instances when the defendant does have to prove something. A kind of the main example of that is if there's what's called an affirmative defense, right? Where the one that everybody kind of knows about and is familiar with is self-defense. If it's a homicide case or something where you are, as a defendant, pleading an affirmative defense saying, I had the defense of self-defense, so this was justified. I was justified in committing this offense. Then you have to prove that defense up. You now, as a defendant, have a burden of proof because you have to prove that you, as a defendant, meet all of the elements of that defense, whatever it is. And so that would be when a defendant's case in chief becomes vitally important, because if the defendant doesn't prove those elements, then when the jury goes back to deliberate, they are going to be instructed that the defendant did not meet all of these elements. They didn't prove all these elements. And so you can't consider self-defense as a justification for the commission of this offense, right? So that would be an instance when a defendant's case in chief becomes incredibly important. The other thing that I want to touch on that most people aren't aware of that actually exists is between the government's case in chief and the defendant's case in chief, after the government rests, the defendant will typically, or the defense lawyer will typically make a motion. And this motion is to the court. It's outside the presence of the jury. And it is a motion, what's called a motion for instructed verdict is what it's called in the Texas state side. On the federal side, it's called a Rule 29 motion is typically what it's referred to as, because it is referring to a specific rule of criminal procedure, obviously Rule 29 of criminal procedure. And what that says is that if the government or the state failed as a matter of law to prove each and every element of a criminal offense, then the case can't even go back to the jury. That the judge has to rule right then and there, state you never proved this element because you did not elicit any testimony or you did not offer a single exhibit that touched on this element. And so as a matter of law, The jury doesn't even get to consider this case, and we're issuing a finding of not guilty, a verdict of not guilty. Okay. So those motions are very, very, very rarely won by a defense lawyer. Very rarely. Now, it happens. It does happen, but it's incredibly rare. And yet those motions should be made in every single criminal trial that ever occurs. And the biggest reason why is because if that motion is not made, then there is a great risk that if the defendant is ultimately convicted and sentenced and sent to jail and then wants to appeal the verdict, a lot of the arguments will either be waived because they failed to make that motion, or they will be subject to a much harsher standard of review by the appellate court because that motion was not made. And so by making that motion, you are preserving, or the defense lawyer is preserving, so many appellate issues that can then be argued on appeal. And so if a lawyer fails to make that type of motion, it's almost tantamount to being ineffective, right? So it's a very overlooked, misunderstood, but super important part of the trial, especially for appellate lawyers when they go back and they're reviewing the transcript and like, this lawyer didn't make a Rule 29 motion. So now it changes the entire outlook of what that appeal looks like. So, like I said, other than those kind of two caveats, the defendant's case in chief looks very similar to the prosecutor's case in chief or the government's case in chief, so you kind of know what to expect. As always, I hope this information was helpful. I hope it was at least mildly entertaining. Please drop a comment down below if it was or wasn't, or if there's something specific you want to see me answer in a future video. I'm always happy to see what it is you guys are interested in hearing me talk about. As always, I will be on my live stream on Sunday evening at 7:45. So if you have more questions, just jump over there and let's chat about whatever it is that you want to chat about. Until I see you guys next week, I hope you have a great, great weekend, a great week next week. Stay dry, stay safe, be good, and stay on the right side of the bars.